Welcome, everyone. Great day, great day. Got a very special segment for you today. I have a very special guest in the studio, Mr. Steven Brewer. And today we're going to be discussing all the things that you like to talk about in this space. We're going to be talking about birth certificate bonds, monetization of debt, bonds, public and private, secure party, all the things that that circulate around in the echo chambers. And we're going to try to dispel some of the myths and separate the reality from the fiction. All right, so we're going to get into that. So stay tuned, grab you something to drink. We'll be right back. Welcome back. I want to welcome you today. As I said, we have a special guest. But before we begin, I'd like to take an opportunity to invite you to my website to pick up my latest ebook. Within that ebook, there's a lot of information that's going to help you understand a lot of the foundations of the things that we're discussing here today, as well as an added bonus for you to pick up the ebook. So go over to spcuniversity.com and pick up the ebook now. And without further ado, welcome, Mr. Steven Brewer. How are you doing, sir?
Oh, man, it's a pleasure. It's a pleasure. I'm really glad to be here. And I was kind of shocked about some of the stuff you wanted to talk about. I know we had the first episode that you wanted me to host, and I thought that was hilarious.
I thought it was very, very good. We still got some.
I enjoyed it. I actually enjoyed it. You kind of motivated me. And so when you invited me back, I said, sure.
Okay.
Sure.
All right.
And I was quite shocked about the topic. You've always been wanting me to come and talk to you about DTC. And I was like, who?
It's needed. It's needed, brother. You have to understand that the DTC, that information is a specter that is running behind all this information that we're talking about. However, it only goes up to a certain point.
Okay.
And then people, they get lost. Okay, they know they hear about the DTC and they say our birth certificate got monetized and it's being traded through the DTC. It goes like this. When I came into this space, we were told that the birth certificate originates first with vital statistics.
Okay.
And then it goes to the Department of Commerce. And then from there, it goes to the Department of Treasury. And from the Department of Treasury, it goes to the DTC, what we're going to be talking about in a little bit, and to a holding company called Cede Corporation, CEDE. And I happened to look up the definition of that word, and it happens to mean relinquish. And, it made me think, are we relinquishing some sort of rights or something, when we get a birth certificate? At least that's the prevailing sentiment that in some kind of way, when we get a birth certificate, we've relinquished a portion of our sovereignty to the federal government. And I'm not really sure about that. Some aspects of it have made sense and some don't. I don't believe that the birth certificate puts us into a contract. I happen to think it's the social security number and the acceptance of benefits and privileges that attach jurisdiction of the federal government commercially in that certain circumstance. But other than that, I'm going to let you talk for a little bit. What are your thoughts on this? And, because I know you're familiar with it and so forth.
First, I have to say when I met you some years ago when we were much younger,
yes,
I was very intrigued by some of the information that you shared with me that I paid attention to, I looked into. And of course, as you know, I've been in the sector of privatization of bonds, monetization of bonds, corporate bonds, private bonds. We work with different firms, different companies to help them structure their bonds on the private side or the corporate side in order to monetize them for projects and even humanitarian projects. And quite frankly, we're working on a structure now for a large humanitarian project in Bolivia. So very familiar with the structures in the space, especially as it relates to the DTC. And I know times back when we talked or we met, when I was listening and looking into some of the information that it related to perhaps the sovereign movement, but not so much the sovereign movement, but more of the privatization of how an individual can work outside the boundaries of the commercial.
Right.
So very intrigued with the information. I've heard a lot. I've listened to a lot. In fact, I got to be honest with you. I, too, myself looked into seeing how I could monetize my birth certificate because in theory, it sounded really good. Quite frankly, it was the first time I became familiar with 55 Water Street. And believe you me, I showed up. I couldn't find anything there, but I was willing to go where no one would go.
Well, you deal in that space of, private instruments, bonds. You've been doing it for quite a while. As a matter of fact, when we first met, that's what you were involved in. You weren't even privy to any of this information in this space, but you were already traveling the world dealing with monetization of instruments when I first met you, probably some 15, 20 years ago.
Yeah, I've been dealing in the private banking space. You have a retail banking, and then you have private banking. And private banking is typically where these transactions interact. And they're structured in such a way that it's very conducive to your circumstances. It's almost crafted or created in structures that benefit both parties. What I mean by both parties, of course, you're going to have an individual that's bringing a bond to the table or an instrument, negotiable instrument, that wants to either monetize it or utilize it for trade purposes to work on their project or to fund their project or to fund a humanitarian project. And so in the course of those structures, there are entities that one have to deal with, such as the DTC. So what is the DTC? Everybody understands it as a Depository Trust Company. And basically, just to describe it, it's just a privately placed location for bonds to move through, okay? Individuals create their bonds. I think if you go back in time, there was an individual called Michael Milken. You may or may not be familiar with.
I'm familiar with him.
He was the creator of what was called junk bonds.
Right.
Ultimately, penny stock and things that fall in that category that had very little value. But with Michael Milken, he was able to take these junk bonds and actually create a small value, but he created millions behind it. And a lot of these corporations, they structure their bonds tied to their company. They come up with the value. Let's look at Shark Tank. Mr. Wonderful would often ask you, well, what's your valuation? And these people would say, oh, my company is worth $3 million and I'm offering you 20% of it. And Mr. Wonderful would say, well, how did you come up with that valuation? Well, they basically came up with a junk bond figure. Because what they did was they took their sweat equity, they took the inventory that they had, and they took perhaps the cost of their building, they took the money that they've already borrowed, and what they did was created a value. That valuation, whether it was substantiated or not, is how they came up with what they thought their asset was worth, their company. So Mr. Wonderful says, I can't give you that valuation. At best, I'll give you this figure. Well, that's the way it works with corporate bonds. You go in and you have to structure and create your value based on your assets, based on the money that's put into the company. And then after you create that structure, you're now able to utilize the DTC through application, through structure, through creating an identifier such as a CUSIP or ISIN number.
Whoa. CUSIP.
CUSIP.
I hear that, floating around all the time. Committee on Uniform Securities Identification Process. We got to pause.
Okay. We'll stop
Tell
there.
me about that, because everybody's looking for their CUSIP number. I found a CUSIP number to my birth certificate. I need the CUSIP number to set off my criminal case. And I'm like, okay, well, what are you going to do? I'm always asking them, what are you going to do with the CUSIP number when you get it?
Well, let's talk about the CUSIP number. CUSIP number is, of course, a U.S. Derivative of a identifier.
Okay.
And the ISIN is an international identifier. And so let's take your corporation, for example. In order for you to even begin to do business on any stock exchange or DTC, you need to have an identifier that helps an individual identify your particular instrument, whether you're monetizing it or not. In order for it to be recognized, information to be provided, it has to receive that certificate or that identifier.
Okay.
As you work with DTC, DTC definitely have to have that identifier, because once you go through their application process of planting your instrument, your certificate, or whatever you want to call it, when it's placed there in the depository, it now has to come with information that backs up your claims. So, valuation, for example. I tell you what, let's do this.
Okay.
You're familiar with chat. Let's look up DTC in your chat.
Okay.
And see what is the process of validating a monetizable or an instrument that is placed on deposit with them, so that your viewers can get a full understanding of what we're talking about.
An instrument placed
on deposit
with the DTC.
Now, so that you understand, any instrument now that's placed on deposit becomes a security. Okay? And through DTC is basically an electronic entry book. Back in roughly about 1970, 73, the Wall Street had so many certificates, okay, that as they were creating all these bonds, Michael Milken being one of them, they were physical in form. So the Depository Trust Company formed its company to be able to house and facilitate the documents, but in electronic form.
Okay.
So it went from you actually holding a physical bond in your hand to electronic form that now shows up into their depository, but yet you can see it on the screen. You can identify what it is, and you also can determine the value of it. Okay. So now let's go to your definition.
Okay. Well, it says the validation process for an instrument deposited with the Depository Trust Company, DTC, is a formal securities processing procedure. It is not a determination that an instrument has intrinsic value or that it can be monetized simply because it has been deposited.
Now let's stop right there.
That was interesting.
If you take the birth certificate, and in the space, they've already predetermined a value. Am I correct?
Yes, a lot of people think, there's a video on the internet, a woman, she said, your birth certificate is worth billions. And I'm going to put it on the screen right here for anybody who wants to go to YouTube and see it. But I'm like, where did that come from? You said your birth certificate is worth billions.
So now let's look at the two. I'm not going to dispute the $1 billion value.
Okay.
What we will look at is, how does DTC determine the value? Because if now you're on the march to go to DTC and you think it's housed there and you have a value, what is DTC saying? The definition.
That it doesn't determine the value of the instrument. It says it is not a determination that an instrument has intrinsic value or that it can be monetized simply because it has been deposited. The purpose is to ensure that securities accepted into the depository are authentic, legally issued, transferable, and eligible for settlement.
Correct. Now let's talk about the settlement portion. Typically, the reason for one housing their instrument there, their security, is because they plan to create some form of settlement, basically the sale of it or the use of it by an investor. So you have to create some form of settlement because when it's said and done, that security has a maturity date. It is also has a coupon and an interest.
Wait a minute. What is maturity date? What happens on a maturity date?
Okay, good question.
That's I think kind of murky right there.
Good question. So case in point, I have a corporate bond and I decide that I want my bond to have the life shelf of 10 years.
Okay.
What I do is I attach a 10-year life to it. From day one, it becomes due in 10 years. My goal is to be able to utilize this bond over a 10-year period, offering it to an individual that finds the value and they're able to use the bond because it's tied to some form of an asset or collateral that validates the amount of value that they place on it. Let's use a corporation. Let's say that they create corporate bonds to the tune of $1 billion. Well, it's easy for me to say that it's $1 billion, just like the individual told Mr. Wonderful what their company was worth. Mr. Wonderful found it hard to believe because they didn't have enough data to support that. So in his negotiations, he negotiated an offer and compromise based on the value he placed on it. Well, same way with corporate bonds. In order to create the value that you're assigning to it, you have to attach it to some form of an asset, something that's verifiably of value. Case in point, we're working with a corporation that they're a mining company out of Australia. He created a bond against his mining company to the tune of $3 billion. Well, what he did was he put the cart before the horse. He went in and created the bonds, but he didn't go and create the value of the mine.
The assets backing it.
Correct. So there he has a $3 billion bond that's sitting on DTC, but DTC doesn't have the means to validate its value, but it is housing the security. It has a ISIN number because it's an internationally created bond. But me, if I want to come and now make a settlement with him, I'm saying, well, where is the value? If you default on our transaction, how do I recoup? Or how do I not lose? Well, there has to be proven value there. So in the course of what we're doing, we're working with the individual, with another individual with mining and minerals, where they need revenue to help them mine. And so we're merging the two, where this individual didn't put the cart before the horse. They paid money to have an analysis, a validation, basically an appraisal. And the way that's done in the mining sector, it's called a NI 43 report, which utilizes a qualified engineer that's certified and also listed on the Canadian Stock Exchange for individuals that have the ability to validate minerals. What am I saying? I'm basically saying that in order for my original client to utilize and make settlement on his bond, he has to have a value there. So we're merging the two to create that value. And ultimately, we'll be able to settle through the DTC an individual that's willing to take his bond when it's due in 10 years, a coupon rate that's attached to it or an interest rate is due at that time. That means in 10 years, there's a calling point of interest payments. So, but how do you attach that to a Social Security number? That would be the question. I mean, not a Social Security number, but to a birth certificate. But if you don't mind, let's go back to your definitions, because I know I went a little bit over. Let's go back to
Well, no, that was very, very interesting. It seems like, before I do, it just seems, I want some clarification. It seems like the DTC and listening to you, it's like a place you go where we can go to the table and offer our wares and show like, hey, look, I got a bond which you could use. So it's a place, it's like a store where you can kind of go in, examine bonds, see, and then say, hey, this looks interesting. However, is there an asset supporting it? How am I going to get my money in case there's some sort of default or something like that? Is there an asset attached to it? Sounds like securitization is involved in this a little bit.
Absolutely, absolutely. Because of the simple fact that there's a settlement process. But in order for an individual to make a settlement, one has to have enough information to want to enter into an arrangement or an agreement or a purchase or whatever the case is to make a settlement. And DTC is nothing but the depository house for that document electronically, not manually.
All right. Well, let's finish this. Let's get to this definition because this is getting very, very interesting. I'm learning some things here and I'm clearing some of the confusion. The validation process for an instrument deposited with the Depository Trust Company is a formal securities processing procedure and is not a determination that an instrument has intrinsic value or that it can be monetized simply because it has been deposited. The purpose is to ensure that securities accepted into the depository are authentic, legally issued, transferable, and eligible for settlement. Now, here's how the process generally works. Number one, eligibility review. Before an instrument can be deposited, DTC determines whether it's eligible for its depository services. The issuer or its transfer agent typically submits security terms, offering documents, legal opinions, corporate resolutions, issuance information, CUSIP or ISIN information if applicable. This sounds like a paper game.
It's exactly what it is.
It's just a paper game.
Exactly. Because when we go and validate the minerals, we're not taking them out of the ground.
You ain't taking it out of the ground.
No, now I have a document that says that it's valued after, of course, my engineer drills, let's say 100 holes. The drill goes down, it bores, they test. They says, wow, you have over $1 billion in minerals or assets in the ground. They take that value, they attach it to the bond. Now it's monetizable. You see, there's steps in order for these things to take place. That's why it's so important to understand the role of the DTC, how you're actually able to monetize something after you structured it with a CUSIP number or ISIN number. And for your listeners, those that have the process down for birth certificates, I can't say that you can't make it work. That's not my determination. What my determination is that there's a process.
Right.
There's a reason for the DTC. There's a settlement process. There's basically a buyer and a seller. Okay. Ultimately, even if you're operating with your birth certificate, who's the buyer, who's the seller? Who's the individual that's gonna at the end of a maturity date, there's a reckoning, there's a settlement.
And what asset are you offering for them
Is that
to collect?
yourself?
Is that you?
Correct. So you have to dig a little bit deeper as you take on that philosophy or that mindset. And I'm here to break down what the principles of the structure is of the DTC. You have to stop and think of this, and this is more in your territory. DTC is nothing but a limited purpose trust, okay? ChatGPT, what a limited purpose trust is for.
I'm pretty, just from the name of it, it's constructive to accomplish a specific goal. Right? It's not just, because in the trust world, when you write the terms of the trust, it can give the trustees broad latitude to engage in a lot of different things, or you can narrow those purpose and that scope.
Absolutely. And it's designed just for that reason. Here's the thing that most people don't know, that the DTC is a member of the Federal Reserve System.
I didn't know that.
Yes, it absolutely. In fact, the Federal Reserve has oversight over DTC.
Wow.
Now, why is that important? Because a lot of the information that you're feeling that you're missing, under Freedom of Information Act, you can get anything as it relates to DTC, procedures, rules, regulations, because it falls under that federal regulation. So if you're saying, I can't find this, I can't find that in the DTC, well, the Freedom of Information Act.
They can't hide it.
Can't hide it. Can't hide it.
Yeah, I always said that. I always said that they're not hiding anything. That they put everything, they publish everything. You know, they always operate under plausible deniability. A lot of people in this space think that there's secret information that's being held somewhere, and it's been my contention over the years that I've been studying. And it says, no, it's not hidden. You just, you know, the only thing is, it's an old saying. I think it was Carter G. Woodson in the Miseducation of the Black Man, who said, if you want to hide something from a black man, put it in a book. I think it's out there. You know, as a wealthy person, you tell me if you agree with this. He said that, you know, I asked him a question. I said, what's the difference between rich people and poor people? And he just hit me with an answer I was not prepared for. He said, rich people know how to fill out paperwork.
I can't say anything to that, and that's so true. And the reason for it is in all the areas around the world in banking and wealthy individuals that have been around or had the privilege to be around, they're all private. They're all private. They don't operate in the commercial sector in any way.
Would you say that there are more, that the wealth on the private side is greater than, like, there are people that got more money than Elon Musk on the private side?
That's very fair to say, and the reason for that is because the majority of the individuals don't broadcast their wealth. Elon Musk and other individuals that want to broadcast their wealth, and Forbes, by the way, is basically probably the poorest list of individuals. That's correct. Those are for the individuals, not that I have billions of dollars at all, but the fact of the matter is that those people are willing to allow the public to analyze who they are, what they are, and that's out of ego. Truly wealthy individuals, they don't have to show it, and they don't show it.
Yeah, I listen to a lot of Kevin Trudeau's shows, and he says that all the time. He said the individual, he said they have wealth, unimaginable wealth, but they're private. And you come to their estates and so forth, it's unimaginable the level of wealth that they have.
Have you ever seen the Rockefellers on the list?
And I always say that. I said, you don't hear about the Rothschilds, who allegedly have 75% of the wealth of the world.
You won't see them on the list.
Exactly.
And if they ever showed up on the list, you probably would never see a Forbes issue again. So to answer your question for your listeners, one has to really process what it means to truly be private. In order to truly be private, you have the benefits that you're seeking. Okay, let's talk about right to travel. Okay, and this is jumping off real quick. If you're a wealthy individual and you have a driver and you don't have a driver's license, do you have a right to travel?
Yeah.
But again, that's another conversation. Here's the point. The generational wealth that individuals are seeking, it's very difficult to be in a space that's denying the very existence of the things that will put you in the place or make yourself able to do those things.
I've said that. I said it requires, well, like a lot of the sovereigns that over the years since I've been into this, they got compounds, they have drivers. You know, when you live in a private world and you don't want a driver's license and all these things, well, there are ways of doing that, but you do it through agents and fiduciaries.
Correct.
And this is what lately I've been trying to teach as far as private ordering. You know,
right.
That's what I discovered. Like, these people operate in an entirely different world of privacy, where they have ordered their affairs in such a way where you never become privy of any of their
In fact,
things.
your book, excellent book, the ebook is just unbelievable.
Yes.
So much information in there. I really encourage your listeners, if they haven't taken the time to do it, because everything is factual. Everything is based and founded on law. What I like about you is you're willing to do the homework. You're willing to dig into it. And I remember years ago when we met, you had different philosophies that you've come full circle on. But everything that I hear you talk about is based on the structure, the Constitution, how people truly operate in commercial, how people operate outside of commercial.
I think it would be, it wouldn't speak well of me if after 20 years I was in the same spot I was when I started off.
Okay.
I read every day for those 20 years, and I'm constantly studying, and obviously I'm going to amend information as new information comes in and my understanding broadens. For instance, like I just had an epiphany sitting here talking to you. We was talking about the securities, and you're talking about, well, what is going to be offered in settlement when these bonds mature. They say, is it you? And that made me think about the statute merchant. The statute merchant. One of two 13th century statutes establishing procedures to better secure and recover debts by, among other things, providing for a commercial bond that, if not timely paid, resulted in swift execution of the lands, goods, and body of the debtor. These statutes were repealed in 1863, also termed pocket judgment. Since too, the commercial bond so established. Expert commentary. It is not a little remarkable that our common law knew no process whereby a man could pledge his body or liberty for payment of a debt. Under Edward I, the tide turned. In the interest of commerce, a new form of security, the so-called statute merchant, was invented, which gave the creditor power to demand the seizure and imprisonment of the debtor's body. In 1100 under Edward I, where he created this system where people could pledge their bodies for the repayment of a debt. And see, that right there evidences to me, well, okay, if you're pledging your bodies, okay, that to me is there are ways to pay a debt other than giving money. So is there some credence to when they say you need to pay your debt to society when they put you in jail? And this what led me to, I'm like, okay, well, maybe the body can be retained to collateralize a bond. But how is that value determined? And so I started thinking, well, there's an actuary table. And, if you really think about this and say, okay, well, people work from around 18 to 65. Why do they give those numbers? Do they have to have a number set in place so they can, some hard number, 18 and 65, and they can calculate, okay, if you have a minimum wage, they don't have a maximum wage. But if you take the average person and calculate from 18 to 65 at minimum wage and get a value from that, now you can pledge that and say, okay, we got people being born, they're going to work from 18 to 65. At a minimum, they'll make minimum wage. Here's the value of that person. Correct. Hey, can we get a loan for that? Extended a loan. That sounds feasible to me.
And I can't argue that. That does sound feasible, but let me ask you this question.
Okay.
If DTC was founded to create a paperless system, yet you're determined to go get your long form birth certificate, get a CUSIP number, and then do what with it?
Try to set off debt, what they call set off debt. That is the purpose of it. In other words, you understand we're in a debt-based system.
But how do you create your settlement, or how do you create a relationship with DTC? That's what I'm asking. How would you create that relationship? You said it's sitting in a Cede?
A Cede corporation, CEDE, Cede corporation. If everybody puts in...
please enlighten me on that one.
What is Cede corporation? I know it's a holding company. Cede corporation. Okay, Cede and Company is the nominee name used by the Depository Trust Company to hold legal title to securities on behalf of the DTC participants. In other words, Cede and Company is not an investment company or a bank. It is a legal entity whose purpose is to facilitate the efficient holding and transfer of securities within the U.S. financial system.
Okay, so what we know it as the clearing corporation.
Yeah.
That's what we know it as. That's probably the first time I heard the word Cede. But typically, well, not typically, when we're communicating, it's a clearing corporation. So go ahead.
Okay, it says, why does Cede and Company exist? Before electronic trading, every stock sale required physically moving stock certificates between buyers and sellers. As trading volume exploded in the 1960s, this became unmanageable. The solution was place most stock certificates in one central depository, DTC, register those certificates in the name of Cede and Company, transfer ownership electronically through bookkeeping entries instead of moving paper certificates. This is known as the book entry system.
Correct.
How ownership works. Suppose you buy 100 shares of publicly traded company. Legally, the chain of ownership usually looks like this. The company issues shares. Shares are registered in the name of Cede and Company.
But wait a minute. You notice it said a chain of ownership.
Chain of ownership, yes.
So if you're looking at the chain of ownership, and let's just say that for practical purposes, it is placed with the clearing corporation or the Cede, who is it transferring to in terms of ownership? Because that's the purpose of the trust company.
What is a street name? Street name. It is street name. It is because I was told that it's traded in the name of a street name, and that's how they conceal it. It says, in the securities industry, street name refers to a method of holding securities where the shares are registered in the name of a broker, bank, or nominee rather than in the investor's own name. How street names registration works. Suppose you buy 100 shares of a publicly traded company through a brokerage account. The ownership chain typically looks like this. Company, Cede and Company, registered owner, DTC, your broker, and you, the beneficial owner. And as they use this word beneficial owner a lot in these circles, but it says, although the shares are registered in the name of Cede and Company or another nominee depending on the custody chain, you are the beneficial owner. That means you generally have the economic rights associated with the shares, including receiving dividends, selling shares, receiving stock splits, exercising your voting rights through proxy materials, and receiving corporate communications. Why it's called a street name. Historically, brokerage firms were located on Wall Street and other financial districts. Securities held in the broker's name came to be known as being held in a broker's street name. Advantages of holding, so it's held in a broker's name, essentially. So advantages of holding securities in a street name: faster settlement of trades, no need to handle paper stock certificates, reduced risk of loss or theft, easier dividend processing, simplified transfers between brokerage accounts, automatic handling of corporate actions, splits, merger, tender, offers, etc. Street name versus registered ownership. Street name, the broker or nominee is the registered owner. Registration ownership, the investor is the registered owner. Street name, the investor is the beneficial owner. And a registered ownership, the investor is both the legal and beneficial owner. And a street name, it's easier to trade, and a registered ownership, transfers can take longer. And a street name, standard for most brokerage accounts, and a registered ownership, often used by investors who want shares registered directly. Direct registration. An alternative is the direct registration system where your shares are recorded directly on the issuer's books through its transfer agent. In that case, your name appears on the company's shareholder registry. No physical certificate is required. The shares are not held in your broker's street name, although they can later be transferred to a broker if you wish to trade them. Important distinction. A common misconception is that because securities are held in the street name, the investor doesn't own them. That's not accurate. Under the standard broker and custody system, the broker or its nominee holds legal title for administrative and settlement purposes, while the customer retains beneficial ownership, obviously because it's a trust.
And let me self-correct myself. And you're absolutely right about the Cede and Company. I was thinking Cede because
I said Cede. A lot of people pronounce it as Cede.
Yeah, it is actually Cede. So when you said Cede, I was like, what is that? But the reality is that's where the DTC nominates them as the registered holder of every deposit. Cede and Company is the correct terminology. So now I guess I'm processing what they're saying, because I was like, okay, how is that being played out? And it's not the clearinghouse, but they would actually deal with DTC because that is their nominee. That company is their nominee for registered holder of record.
Well, the reason I called it Cede Corporation is because when I first started studying this and it was brought to my attention that they were the holding company for the DTC, I didn't have anybody. I just saw the word. Nobody said it to me.
Cede, yeah.
However, I was in a state where I looked up the definition of every word I came across. So I went to the dictionary and looked up Cede Corporation.
Okay.
And it means to relinquish.
That's okay. You're from Texas. I forget.
So it's like concede, like when you concede defeat.
Yeah.
Okay. So I'm like, well, cede means to relinquish. So are we relinquishing some sort of interest in an asset? Because I'm looking right here. You put it in a trust, you no longer own that asset anymore, though you have a beneficial interest in it.
But I want you to think about even the structure of DTC. They hold those documents or instruments, but notice what Cede does. Cede is the registered nominee. You have yet another layer of protection for a trust. When we continue to follow the structure, this private structure, and even though it is regulated by the banking regulatory agency, there's still certain aspects that they can't penetrate. So they're structured legally within the laws of the New York Commission, but at the same time, for an individual that really needs to follow their doctrine, you still can go through the process of finding the information out. It's not hidden information.
However,
it's not confidential information.
The question, though, if it's being traded in a street name, one thing about trust is anonymity. People utilize it to remain private. That's one of the things. Your name is not on nothing. Now, the Rockefellers coined a phrase, own nothing, control everything. Don't put anything in your name, because with ownership is liability. So it also appears to me, because the Depository Trust Corporation, and as I'm reading this, I'm seeing more and more. I mean, this is a trust. This is all trust terminology.
They're a depository. Now the question would be, if a person is saying, okay, that is registered, nominated by the DTC Corporation, who's the owner? Who's the buyer?
And that's what it comes back to at the end of the day. Who's the owner?
Who's the owner? Who's the buyer? And of course, the individual saying, I'm the owner, the holder of the birth certificate, and he hasn't been notified of any trade. Okay, I can understand that philosophy. But there's still more steps to the process that has to be determined before you can conclude that that's where you stop and go get your money, or your value, or to receive compensation. And so those are the foggy points that's difficult for me to follow in the information when I first read it, when you handed me the book on redemption, 15 years ago.
Yeah, and that's where it was foggy with me too. But as I began to start, studying trust a little bit, a lot of clarification. Like as we're going through this right now, I'm seeing some things, with the street name, with the bonds, because we're in a debt-based system. So you tell me if I'm right. And my understanding is, debt is being used as money.
Absolutely. That's the only way that you can create money.
You have to create a debt to have money.
Absolutely.
And so in other words, they like discount. Like for instance, I was in real estate, and they have something called notes. Discount note market, where
everything is a note, pretty much.
Everything is a note. So you can take a note. Let's say I do a owner finance.
It's a promise to pay.
Promise to pay. Let's say I do an owner finance on a house, and let's say the house is $200,000, and I'll take you. You come and you buy a house from me, and we do a mortgage, and we make it for 30 years, and you got a house note $1,000 a month.
Correct.
All right. So now you're paying me 2 years in, you're paying me, and you know what I'm saying? You know what? He's paying me $1,000 a month, but I want all of my money now. I'm tired of this mortgage. So I'm going to go to the bank. I'm going to discount it. I go to the bank. I say, look, I got a $200,000 note. I need an influx of cash. I'm going to discount it to $150,000.
Correct.
All right. This note has a 7% interest for 30 years on it. Okay. Mm-hmm. And if you give me $150,000, I'm going to give you this $200,000 note. Well, this guy has been paying on time every month $1,000 at 7% interest. Mm-hmm. And is that kind of how that goes?
That's exactly how it goes. J.P. Morgan Bank or any other bank wouldn't last if everybody paid their bills. Just wouldn't last. A promise to pay is what creates the value. I have the ability to go to you. You made a promise to pay, and what you have did was I gave you $5, and then you promised to pay me back $10.
Right.
J.P. Morgan takes your promise to pay and then goes to their lender, and they get $7. This is okay. Here's what you do is you give me the $7, and then at the end of the payment, you'll get his $10. Well, if you paid your bill on time and you accumulated a $5 note and you immediately paid the $5 note, someone loses there.
Somebody is going to lose some money.
There's no additional
because there's
revenue.
no interest.
That's
they lost
correct.
out on the interest.
That's correct. So if you walked in the bank and you said, I'm going to pay cash for my own house, and you're ready to take your cash out of the bank, J.P. Morgan is very upset with you. The banker says, no, stop. Don't do that. How about if I loan you the money? And you're like, well, what is that going to cost me? So it won't cost you that much. We'll spread it out over 30 years and just leave your money right there. Why do you think they do that?
Because they need to create some paper. That's why I fought in the foreclosure arena, and that's when I kind of got, privy to this. I'm like, because, they're so quick to foreclose. I was noticing how they do because they get to make new paper.
That's correct.
They get the asset back. They already got all that money from you. They get the asset back and makes a new paper.
They get to regurgitate it.
Wow.
And it's a continual system. It's a foreclosure mill, and that's how it works. And as you know, half the documents that they signed were rubber stamped and not even processed properly in due course. That's why so many people were winning foreclosure cases in court. So debt is a necessity. One of the reasons why, unfortunately, for a lot of people, they're complaining about the national debt. Well, there's a reason why they run it up. Because they're able to go and take that new debt and run to China and bring in more money.
This gives new meaning to me in my mind. I'm sitting here thinking in the Bible about the money changers. Mm-hmm. And, what is a money changer? I was always wondering. A money changer is an individual or business that exchanges the currency of one country for that of another. Historically, money changers were the precursors to the modern banking system, originating thousands of years ago to facilitate trade and travel across regions with different coinages. Today, this function is primarily handled by digital platforms, retail banks, and dedicated currency exchange bureaus. The Jerusalem Temple. In the first century, pilgrims traveled from all over the Roman Empire to Jerusalem. They were required to pay an annual temple tax in a specific high-purity silver coin, the Tyrian shekel. Money changers set up tables in the temple outer courts to exchange foreign currency for the shekel, often charging exorbitant fees and manipulating rates. This practice directly prompted the biblical account of Jesus overturning the table, Greek trapeziti. In ancient Greece, money changers operated from benches or tables called trapeza. Over time, they expanded from simple coin evaluation to accepting deposits, maintaining accounts, and issuing commercial loans. The Italian benches. During the Middle Ages, international trade fairs across Europe required merchants to constantly convert foreign coins. Italian money changers work from outdoor benches known as banchi. If a changer failed or cheated clients, his bench was physically broken, leading to the term bankruptcy, from the Italian bancarotta. The rise of paper claims. To minimize the danger of transporting heavy gold and silver coins across dangerous trade routes, money changers began keeping coin deposits and issuing paper receipts. These receipts eventually circulated as independent stores of value, laying the groundwork for the modern banknote and commercial banking system. In the contemporary financial ecosystem, physical money changers are known as bureaux de change or currency exchanges. If you need to convert currency today, options vary significantly by cost and convenience. Wise, an online multi-currency account platform that converts money using the real mid-market exchange rate, bypassing high traditional banking markup fees. Z Currency, a digital provider offering live exchange rate trafficking and international online money transfers funded via bank account or card. Currency Exchange International, a retail foreign currency exchange operator with physical brick and mortar branches and home delivery options for physical foreign banknotes. But then I say, they're just changing money from one form to the next. It's jumping from a bond to a Federal Reserve note to a promissory note at interest. And it's just taking on different forms of money and people discounting it and things like that. So it's a game. It's just a game.
It's a game. They take their books. The money changers would take their books and then they would go to their investor and it says, okay, I just made you $500. You only gave me $300. Now give me a fresh batch of money. So everything is tied to the debt. Everything is structured. Everything is structured that way. So at the end of it all, how well do you know the system? How well do you take time to find out how your private matters interact with commercial? And that's what one has to be astute in. They can't take it face value. They can't read something off the internet and think that they can walk into a court system or they can walk into the federal system and there's not repercussions because they didn't simply follow the process. This commercial structure that was put in place for a reason. And it was designed for individuals that walk into the commercial arena. They're going to pay.
There was a man, his name is Colonel Mantelhouse. He was an aide to Woodrow Wilson, who is the one that actually passed the Federal Reserve Act into effect. But he made an interesting statement, and it's always stayed with me. It was, the people who understand the system are going to love it, and the people who don't understand it are going to hate it.
Correct. And that's why the masses hate it.
But when you understand it, you love it.
You love it. There's no greater system. There's no greater system to protect people with billions of dollars. There's no greater system to protect.
Nancy, you got people out there right now. They're like, oh yeah, them rich assholes. Yeah, that's what you're doing right now. You want to protect all the people with money while they are oppressing us. Are people being oppressed? Can you really say that since it's a great system, when you understand how the system operates, can you say that you're being oppressed, or you're a victim of your ignorance?
Well, that's a trick question for me. As you know, I like to be neutral in my approach. Let me put it this way. An individual can choose not to educate themselves and live under the constraints of that. Mm-hmm. Or they can, and then they can free themselves. But that's for them to determine what type of lifestyle they choose. I want to say, 8 years ago, then candidate Trump was on a stage with Hillary Clinton. And she said, you don't even pay your taxes.
Did you use that $916 million loss to avoid paying personal federal income taxes?
Of course I do.
Of course I do. And so do all of her donors, or most of her donors. I know many of her donors. Her donors took massive tax write-offs.
So have you not paid personal federal income tax?
A lot of my write-off was depreciation and other things that Hillary, as a senator, allowed. And she'll always allow it because the people that give her all this money, they want it. That's why. See, I understand the tax code better than anybody that's ever run for president. Hillary Clinton, and it's extremely complex, Hillary Clinton has friends that want all of these provisions, including they want the carried interest provision, which is very important to Wall Street people, but they really want the carried interest provision, which I believe Hillary's leaving. It's very interesting why she's leaving carried interest. But I will tell you that, number one, I pay tremendous numbers of taxes. I absolutely used it, and so did Warren Buffett, and so did George Soros, and so did many of the other people that Hillary is getting money from. Now, I won't mention their names because they're rich, but they're not famous, so we won't make them famous. Okay?
Can you say how many years you have avoided paying personal federal income taxes?
No, but I pay tax, and I pay federal tax, too. But I have a write-off. A lot of it's depreciation, which is a wonderful charge. I love depreciation. You know, she's given it to us. Hey, if she had a problem, for 30 years she's been doing this, Anderson. I say it all the time. She talks about health care. Why didn't she do something about it? She talks about taxes. Why didn't she do something about it? She doesn't do anything about anything other than talk. With her, it's all talk and no action.
It's just awfully good that someone with the temperament of Donald Trump is not in charge of the law in our country.
Yeah, because you'd be in jail.
Secretary Clinton.
And he walked up to her real cool and says, "That's not my fault. You created that." And actually she did. She was one of the senators that voted on the tax structure.
And he said, you're not going to change it because all your friends, you benefit from it, and all your friends do, and all your supporters who give you money, every one of you benefit from that, just like me.
Correct. And while she thought it was a dig and thought he would take it as one, he basically told the truth, and it shut her up. Because reality is, when they checked the record, she had voted for that same tax benefit that he was taking advantage of.
But we can all take advantage of that benefit.
Absolutely. You have individuals who may not fully understand tax ramifications, and that's fine. Everybody's not going to stop and take time to do that. Mm-hmm. But what you do is find the expert who understands it.
Right.
And you bring them in. Is it at a cost? Well, it depends on you. What is the underlying dollar amount that you plan on saving versus spending? You have to make that determination. And so many people get caught up in the fact that they don't understand, and they find themselves in a tax situation. And there's a big difference between tax avoidance and tax evasion. I think you probably can go into that a little bit more, and I'm sure you do that with your class.
I absolutely do, and I'm glad you brought that up, because taxes are a big issue. You know, people, there's a big segment of the sovereign community are what would be termed by the government as tax protesters. And as I'm studying, I came in through the door understanding public and private. I got an understanding of this early on in my career. And so when it came to taxes, I began to understand. I said, what is this tax avoidance and tax evasion? Well, tax avoidance is keeping your affairs private where you don't incur a tax. And tax evasion is you've incurred a tax, but you didn't report it, or something to that effect, because you came into the public and engaged in some sort of transaction within a public regulated space that incurred a taxable event, that created some sort of taxable event. And however, I went back to what the Rockefellers were saying. They were saying, own nothing and control everything. And as I began to study all of this, and they say income taxes, and then notice that the goal of the Rockefellers was not to have any income.
Correct.
Okay, so I talked to my CPA. I said, how can I have zero income? And the very first thing he said to me, get rid of that personal bank account. Mm-hmm. You don't need to have any personal income. Everything is a business expense in the public. Everything is a write-off. And that's when I began to tell all of my followers, they look, man, the tax laws aren't designed for employees, they're designed for business owners.
Correct.
All right. And that's where I think some of the confusion about taxes comes in is they think, well, I'm getting into all these taxes and so it's well, with a business owner, we got write-offs on everything. As long as that money is utilized to facilitate commerce, they're going to reward you. But when you take personal income, it's almost like you're taking money out of the public into the private. And anytime you take anything out of the public into the private, there's going to be a huge tax liability associated with that once you remove money. And that's from what I've been seeing, but it all turned on. He told, in my studies is like, if you don't want to have any income, you can't pay yourself. All your expense, you had to put the car in the business name, the payments on the car, the payments on the cell phone. Even when you go to the grocery store, that's to pay for, everything has to be looked at as a business.
I remember years ago, I was in the corporate world, and my CPA, I went to him and I was really complaining about how much, I had to pay in taxes.
Right.
And I was like, is that all the write-offs I get? And he's like, look, you need to open a business. I'm like, what am I going to open a business for? I'm not going into business. I have a very good job. I make a very good salary. But he was very adamant. You need to open up a business. And I did. And when I opened up the business and he says, okay, do you consult individuals? And I did, because I'd always work with individuals, whether it was helping them understand their own business structure. At one point in time, I worked with the SBA, working with small businesses, helping them to get set up through the executive portion of the SBA. I also helped individuals with 8A certifications. Mm-hmm. So when I transitioned from working with the SBA and that structure, I went on to a different corporation in a different field. But so he recommended that I open up the business. When I did, I ultimately opened up an LLC, and I was able to then take the tax benefits of the business meetings that I was having. I was able to take advantage of the business trips and gas that fell outside my normal work. So what's the point of that? The point of it is that there are several structures that are designed not to evade taxes, but to take tax benefits. And I understand there are a lot of tax protesters. There's a lot of individuals on the right and the left that feel that taxation is not appropriate, is not right. Right, wrong, or indifferent. The question still comes down to what is the repercussions, so to speak,
exactly,
from the federal government? Are you willing to put your family through the repercussions because there's an audit and you're found to want to take on a status that has not been acceptable by the IRS, where you may find yourself, well, I'm not touchable. I voluntarily can do my taxes. So what's the word voluntary mean?
They think it means voluntary means I have a voluntary right to pay or not to pay. But the IRS has made it clear, along with case law, that voluntary means voluntary reporting of how much you want to report and things like that. That's what it means. But they have interpreted it as to mean, well, I can voluntarily pay or not to pay. And this is one of the things that I see. This is one of the points, I'm glad you brought that up, that I see that is very, very, has run rampant throughout here, is this interpretation, these incorrect interpretation of words and legal terms. You know, how they interpret voluntary. I say that's not what they mean. Like the other day, somebody, they interpreted the word opinion. They said, well, you just told me the opinion of the judge. Well, that's not what opinion means. Opinion in legal terms means the judge's ruling.
It's findings.
It's findings, all right? It doesn't mean he's offering you his opinion on something, all right? But and this is what I meant when I first came in, I was given a warning that, Look, the words in law have a different meaning than they do in everyday parlance. And a lot of individuals who come through the door, they aren't given that information. They attempt to translate legal terms the same way they would translate it in, colloquialisms or in the street way. And you can't do that. And that has contributed, in my opinion, to a lot of the confusion that's running rampant in this space.
It is. The problem that we have with that word opinion is because individuals were placed in that position to issue their opinion, with another caveat to it: the appellate court.
Mm-hmm.
Then when you go through the appellate court, then you have the Supreme Court, the highest court in the land. What do they do with the lower court's opinion?
Usually they look for procedural errors first and foremost.
And structural.
And structural errors and so forth, unless they do what is called a de novo review, where they will retry the entire matter and the facts of the case over. That doesn't happen very often, however, and sometimes it does happen. We will review this de novo. You'll see that in their opinions and so forth. But that's what it's. I think a lot of people have misconceptions about the appellate court. They think that in some kind of way, like there's a Carmelo Anthony case, which is recent. You see a lot of individuals saying, well, the all-star dream team now. He has a new legal team and for the appeal. And I'm like, nothing's going to change. It's still the same facts. They have to be looked at.
Correct.
All they can do is look at, we have an individual, he has admitted to doing something. We have witnesses testimony that has not been impeached. So those things are going to be taken into account. And a lot of people, I don't think they understand those things. They think in some kind of way there's going to be some sort of magic happen. Mm-hmm. But unless there is some glaring or egregious
structural issues.
Yeah, on the part of the lower courts. I mean, usually, the judges are going to go with the opinion of the lower court unless they're, I teach, we read a lot of case law and we read a lot of appellate decisions and dealing with trust. And there are some cases that are remanded because sometimes you'll get a judge that didn't really understand equity or really doesn't on the lower court. He didn't understand equity. And then that judge will take the time in his opinion to educate that judge. Mm-hmm. And those are the ones you want to read because he's going to send it back. Now make the changes. That's what they're doing. They remand it back. Look, and it's almost like they, I call it scolding them in legal terms. When you read you're scolding this lower court, you're supposed to know this.
Telling them to get it right.
You didn't know and get it right. And
now, let me ask you this question. You had talked earlier before we started recording that you had a segment, or you wanted to create segments where you break down the case law as it relates to taxation.
Yes.
Tell me a little bit, or tell your audience a little bit about that.
That's what we're going to be doing together. We're going to be discussing, cases, sovereign citizen cases. We got 50 of them we've already pulled, and they're going to be on various topics. Where the first topic we're going to address is tax protesters. And the reason why is because this is one area I think a lot of confusion and we need to eliminate. A lot of people.
Now, is it designed to challenge their thoughts and theories?
It's designed to give them clarity. It's the design. I'm only here to give clarity. I'm not here to challenge them. I'm going to show you what the law says. You can respect it or you don't. A lot of people, they don't respect case law. You'll hear individuals, they think, well, the problem with case law, I'm like, look, we have a three-headed hydra. We have a legislative, executive, and judicial branch of government. The legislature writes the laws, the executive enforces the laws, and the judiciary interprets the laws. Mm-hmm. Okay, they are the interpreters of the law, not you. When I say that, they get offended. When I say you're not the interpreter of the law because they think we the people. I say you're all the people, but you gave a delegation of authority to a group of people who are trustees. Now, if you knew anything about trust law, you would know that once you give authority to trustees, you can't take that authority back. And they are the ultimate arbiter of all property that's been put into trust, not you. So just because you're one of the people, is a process you have to follow. And that process is you got to go to your representatives in your state, and they are representing you as their constituency, and you vote on things as you want. You don't get in the street and start wanting to say, well, we're going to raise a protest or an uprising and so forth because something you didn't agree with based off of your misunderstanding of something too. That's what's so egregious about this, and this is what I want to eliminate. You got a lot of people who are angry and ignorant. And I just want to get rid of the ignorant part. And maybe that.
Do you think you ever will?
A lot of this has been going on for 50 years, man. And it's deeply entrenched into the psyche of a lot of individuals, and I understand why. Because when you come through the door, you're indoctrinated into a certain line of thinking. Okay, it's like first is the person. You know, that's where the straw man theory originates. That the word person in some kind of way constitutes an alter ego, and for a great many years I thought this as well, you know. But however, I've gotten clarification on it. I did a deep dive with ChatGPT. Me and ChatGPT, we went to like a month-long back and forth. A lot of people think I just put something in ChatGPT.
But why do you incorporate ChatGPT? What's your analogy behind that?
Well, first and foremost, this is an amazing technology. It is not Google. It is a tool, and it is an amplifier. In other words, you already got to know something. So my 20 years of knowledge, plus for the last year, I placed every question that everybody has asked me on my YouTube, my Facebook group, my Instagram, my TikTok, into ChatGPT. And it will synthesize all this information. ChatGPT is trainable.
So let me ask you this. Do you follow the information that comes back on ChatGPT, or is it something that you challenge their information? How does that work? Let's go a little bit deeper into that.
Okay, all right. Well, I do challenge on certain points. Like, for instance, you got to understand the principles of law. Like, for instance, we have what is called separation of powers. Okay, that's a constitutional principle, one of the 7. Okay, so that means that each of the individual branches of government cannot exercise the power of another branch of government. So I'm looking at the court system. So
Correct.
Under Article 1, Section 8, Clause 9, the legislature has the authority to constitute tribunals that are inferior to the Supreme Court. So for someone to say that they're operating ultra virus or de facto, when right here in this particular document it says they've been granted the authority to do this, is just ludicrous to me. Additionally, the military has a court. It's called military courts.
Correct.
They have a court system.
Correct.
However, the general population is not brought into those courts.
That's correct.
And then, of course, we have what are called constitutional courts, which are Article 3 courts. And Article 3 courts are the protectors of privacy. That is what their job is. That's what constitutional and non-constitutional mean. Unconstitutional means that the government has exceeded their delegated authority and encroached into the private, and they are the protectors of that. All right. Now, one thing that ChatGPT did confirm for me is that there are 2 U.S. Supreme Courts. There's a United States Supreme Court, and there's a Supreme Court of the United States of America. And now, anything that starts with United States is the property of the legislature. United States District Court, United States person, United States Post Office. They started with United States. So they have a principle called delegation of powers doctrine, where the legislature can delegate powers to the other branches of government. So when they delegate some of their powers, not all, they can't delegate their lawmaking power to the other branches, because that's what was constitutionally delegated to them. But they can delegate rule-making authority to the other branches of government. And why not use the Supreme Court? Because they understand the Constitution. If you get a United States code book, in the beginning of the book, it tells you that all the procedures have been reviewed by the U.S. Supreme Court to make sure they're constitutional. That's why everything is procedural. If they follow the procedure, They are immune, okay? That's why a police officer, he shoots somebody down in the street and they put him on leave for about 2 weeks and they come back and let him come back and say he followed the procedure. We found no procedural errors. The procedures are there to ensure that they remain within the bounds of the Constitution. That's what they're for. All right, so you can't go lodging these things. So, but the thing about it is with ChatGPT, I don't want to get off base with ChatGPT. So with ChatGPT, there are times I did a deep inquiry into this thing, what happened in 1933 with the removal of the gold. Under Article 4, Section 4, we are guaranteed a Republican form of government, okay? Guaranteed. But the only way to access that is my ability to engage in private transactions,
okay,
which has been removed from me because I can no longer conduct those transactions with gold and silver outside a regulated space.
correct.
So now that's where the inquiry starts with ChatGPT, and ChatGPT is firing back, saying, "Nah, you can't do this." And so how can I keep hitting them with, "Well, I'm guaranteed this. I'm going to access it." And then what you do is you get it into a corner where it has to relinquish.
And that's based on facts. That's based on law.
Facts, on law. And that's what I'm using to corner it. Not my opinion, not some echo chamber type theory or something like that. It begins with understanding the constitutional principle as well as understanding the enumeration in the Constitution, utilizing that understanding of that and questioning ChatGPT. If I'm to be afforded this right, how is it I'm being denied access to it? And if I'm not being denied access to it, explain to me how I'm not.
So you're not driven by ChatGPT.
No, I have intelligence. I direct ChatGPT. ChatGPT does not direct me.
Perfect. Because so many individuals stop short of what's coming, intelligence. It's coming, it's here. It's not going away.
It's not going anywhere. You know, they talking about AI like it's going you're going to have a choice not to use it. Listen.
Well, little do we know that it's been here
a long time.
A long time anyway.
It has. Back in the 90s, we were told that there was a central computer in Belgium that a human being is actually tied into, and all of the information that is being put into electronic format is circulated because Belgium is a financial district. And it makes sense to me because I read this document called Silent Weapons for Quiet Wars. And in there, they were talking about how they were going to control the economy. And they needed to get mass amounts of data because human beings are creatures of what? Habit. Mm-hmm. So you can predict things based off the habit. So they do what's called shock testing. In other words, they'll raise the price of gasoline and it's a cause and effect, and they'll monitor what everybody starts doing. How many people start buying cigarettes? How many people either go out more or don't go out more? Mm-hmm. How many people travel or don't travel? They monitor those fluctuations and then they record it. And now they can build a, kind of a framework of your humanity and so forth. And this is one of the necessary reasons why you have to have privacy. Because when you give too much information, they can use it against you.
That's correct. So at the end of the day, when we look at a lot of the information that's floating out there, what's your goal?
My goal is to, first of all, to be free. Mm-hmm. My goal is to personal autonomy and to be free of, and that's not necessarily monetary. What is monetarily? I'm not going to lie about that, but monetarily means that I have gotten my thought processes correct. I'm thinking in a correct, and that's mentally, spiritually, and physically. I'm seeking a balance from all three of those, my health, wealth, and happiness. And ultimately, at the end of the day, is to be happy. And what makes me happy? The fulfillment of my dreams and the accomplishment of my goals.
What do you have to say to your audience?
What I have to say to my audience is this: is that you're not a victim. There are no victims. You're only a victim of your lack of understanding of how law works, both on the natural law side, spiritually, as well as in positive law, which is man-made. Man-made law is a subset of natural law. For instance, I'll give you an example. you have something called mens rea, which means criminal intent. For you to be guilty, the mind must be guilty. So in court, they do an examination and a cross-examination. What are they examining? The mind. They just told you that. For you to be guilty, the mind must be guilty. So we're doing an examination into the mind. The first examination is into the conscious mind. The second examination is into the subconscious mind. That's the cross-examination. The subconscious mind cannot lie. It's impossible. But the conscious mind, which is the seat of the wheel, can lie. And so what attorneys are trained at doing, and this is why they tell people not to put their clients on the witness stand. Even in the Carmelo Anthony situation, there was a reason he didn't take the stand, because his attorney elected not to subject his client to this examination, because it's very difficult. And this is why I tell people, trial is for innocent people, not for people who are guilty, but they think they're going to find a loophole. You're taking a very big risk when you do that. And so, because these people are well trained in psychology and the ability to ferret out the truth. And if you've never been subjected to that, and this is where I do respect attorneys a lot on their ability to do this. And so it's all mental and it's all habitual, meaning that your character is a subset of the habits that you have accumulated. And the goal is to change your habits into a productive manner for wealth generation. And that is what the wealthy people do. So what do you want to do? You want to look how they operate and emulate them. You want to see, you don't get mad at wealthy people. You want to, America is the land of opportunity. You're supposed to want to get rich. That's what you should be trying to do here. You're trying to get wealth. It is the land of fruit, of milk and honey and opportunity. And there is opportunity here unlike any other place on planet Earth. And all I'm doing is trying to not only take advantage of that myself, but to also assist my listeners and my followers also in that endeavor as well.
Wow, that was a lot.
Yeah, it was. But let's get back to the DTC, because I kind of want to get back onto securities and talking about that, because earlier we were talking about the bonds, and I was investigating the prison system.
Okay.
All right. The prison system, is my contention that they are monetizing inmates. And I'll tell you where this has been the accumulation of, where I derived this. I did some research into slavery. I'm going to talk about that. The 13th Amendment says neither slavery nor involuntary servitude shall exist anywhere in the United States, except in the case where you're convicted of a crime. And they'll tell people that slavery has been eliminated. But if anyone was to just look in a Black's Law Dictionary and read the definition of slavery, you will see that slavery has not been eliminated. It actually tells you that the Constitution protects slavery. Okay, it'll say that. It's a servitude. Well, involuntary. Well, the thing is, slavery exists if you're convicted of a crime. So, in other words, if you get convicted of a crime, you're placed into slavery. And in slaves, they were sold, but they were sold using bonds. Okay, I was watching this movie, 12 Years a Slave, and in that movie, the man, he was unjustly placed into slavery because he was in the wrong place at the wrong time. And for 12 years, he lived as a slave. But he got transferred from one plantation to the next. And his first plantation, he had a good owner, and, he was okay. But then he's going to sell him to another plantation owner who was not so great. And he was begging him not to sell him. He said, "I'm sorry, I already sold your debt over." I said, "Did everybody just catch that? He said, "I sold your debt over." So, okay, well, that's why we're exploring this. Can we put a bond on an individual and sell them? And that made sense to me.
Absolutely.
So where was the value of the slave? His labor. They tell you in prison you have to pay your debt to society. Is that just a innocuous term that they're using, or is there some sort of substance to that?
There's substance to it. When you understand how criminal cases and civil cases are monetized. That's what it's about. You have what's called futures. You've heard of that.
Yes, I know futures are.
Everything's tied to a maturity date,
Yes.
a payment due, a bill. An indictment is nothing more than a bill that's due.
Right.
And at the end of the indictment, the reading into the court records, then there's a maturity date, correct?
Yes.
The court system has created a structure, and you can go to jurisprudence, you can look up how this actually works when one enters into arraignment. Arraignment is designed for an individual to basically plead his guilt or innocence. You will never find a judge that will ever allow you to plead guilty at an arraignment. Why is that the case? Because they have yet to prepare the bill that will be due in the future. If you want to interrupt the proceeding, you say, Your Honor, I'm not even here to dispute the facts. Basically, yes, I'm guilty. Let's settle this matter. You'll have turmoil at that point. Why? Because they're not able to create a debt that has the entire amount of money due. That's why a grand jury is put in place. The grand jury is not just a finder of fact. The grand jury is there to have a finder of settlement, to issue the bill. There was an investigation. There was time put by this agent, this agency, fact-finding mission. They put a price tag on that. When it's said and done, and at the end of the day, when the probation department or whoever determines that there's a loss, when it's said and done, there's a final bill. That happens at the pleading. That's when that pleading is read into the record, and now the government is able to create a bill that is now monetizable, that's tradable on the open market. Typically individuals that operate or utilize or even monetize or invest, judges, attorneys, many people in the government, because it's a design system. Well, how do we know that? One, incarceration. When you get, let's use the federal government. It says I'm sentencing you to 188 months. If I'm not mistaken, in the indictment, it breaks down the cost per day.
Yes.
Okay. Well, the bill. Okay. Now you have a futures contract.
Right.
You have an amount, a debt. You have the future amount of the debt. And ultimately, you can take that and monetize it because the individual is the collateral.
Right.
That structure has been going on for I won't say centuries. It's been going on basically since slavery.
Well, we go back, like I said, the statute merchant was in 1100 under Edward I, where a person could pledge their body for the repayment of a debt. It's an interesting thing. ChatGPT, once I introduced it to that concept, it always wants to take me back to that. It said, let's go back to this statute merchant. I didn't know that it was going to be so enthralled with the statute merchant. I had studied admiralty under the clerk's practice under John Hall. It's in 3 sections. And I'd studied that intensely for 6 weeks. And then I did a juxtaposition of the clerk's praxis with the rules of criminal procedure, and to determine whether or not there was some sort of admiralty type relationship within that jurisdiction. And ChatGPT, they confirm that. So a lot of people are going into the courtroom calling it an admiralty, but it's not admiralty. ChatGPT was very clear on that. It said, look, it's not admiralty. They have borrowed the procedural mechanisms of admiralty, and they're utilizing it because admiralty can facilitate commerce a lot better than the common law could. So that made all the sense in the world to me on that fact, and that was why I did a deep dive into that right there. And so they're pledging bodies, and that made sense because they're looking for any reason to create a debt.
Correct.
That's what everybody's engaged in. The courts are involved in it. The banks are involved in it. Private individuals are involved in it. Everybody's looking for a way.
It's a money-making mechanism.
It's a money-making mechanism.
I think you've seen there's movies. There are occasions where you've had judges that were caught at sentencing kids to these private facilities because of the kickbacks that they were receiving. Well,
sure was.
This stuff is real. Information is out there. All of it is not unfounded.
Right.
The question comes down to what are the factual informations or data can you apply to it that will allow you to see it for what it is, not what you want it to be, not what you think it is or what you heard it to be. How do you process it, and what's your capabilities of doing that? That's why I encourage so many people to in this space to get a mentor, to get someone who's willing to take them through facts, such as yourself.
Right.
This space can create a scenario for you and your family that can hurt you, if not dealt with properly.
Definitely. It can definitely hurt you. I wanted to, let me interrupt. I wanted to go, because before I forget, I had another epiphany when you sat there and said, they can't allow you to plead guilty at the proceeding. And, I learned that early on too. In Georgia, they use this term called waive arraignment. Mm-hmm. And so what the attorneys will do is they'll come see you and, come and see you and say, I'm going to waive arraignment. And they'll just say it in waiving arraignment means I'm going to put in a not guilty plea for you.
Correct. In other words, you just take it easy. You relax back there.
Right. They do that to everybody, and that's how they obtain jurisdiction over you and so forth, because that's a form of dishonor. Mm-hmm. And you don't ever waive arraignment, and arraignment is a very, very important part of it. But I'm going to tell you this. I did research on that because I was, I had a chance to look at people's court records. Uh-huh. And what I noticed about mine in particular is that what the attorneys will do is this. They'll visit you, and then they'll say, well, we're going to waive arraignment. And then I'm looking in my paperwork, and everything's timestamped. Mm-hmm. And so he'll come in and put a notice of entry of appearance, and then immediately after that, he'll file a waiver of arraignment, not guilty plea. Mm-hmm. And I was told that, well, it's liability, because you can think about this. When the prosecutor files charges against you, now, one of the definitions of charge is lien. If you get a Black's Law 6 edition, it's called a charge on property. Is lien. That's about the sixth definition in the word. It's like 7 different senses of the word charge. Mm-hmm. And that's another thing. When they say I'm charging you with something, they got 7 different meanings of it. How do you know which one they're talking about if you don't ask?
Why do you think you have to sign a plea agreement?
Because it is some sort of way to facilitate. It's called a signing your name in blank, which allows them to place it on any document they want. And I think, and it's just, I haven't confirmed this, but I think when you sign your name on something in some kind of way, it has tied you into the system when you sign in blank, and now you've become some sort of collateral for them. They can utilize. Well, it's like what you said with the creation of that bond.
Plea agreement. You've just agreed to the charge. You've just agreed to the bill that's due. And so while you're thinking, I'm here to get this behind me and clear everything up, and that's what I'm telling the judge, that is not what you're telling the judge. You're now signing a monetization instrument. Your signature is the value.
Is value.
You're held in surety. That's it.
And that's clear. And everything that like in Georgia, for instance, we have 2 codes. It's OCGA 1711-1 and OCGA 1711-4. And OCGA 1711-1 is the liability of the defendant when he's found guilty. And OCGA 4 is the liability of the prosecutor if they find that the indictment was unfounded. This is the reason that almost 100% of indictments get held over. Like you have to go to, was there a probable cause? And they always find it and bound it over to Superior Court. They do that almost 100% of the time, because if they didn't, the liability would fall on the prosecutor. And you can see in there that that they said they would put a lien on him, which is they'd arrest him and put him in jail. And you need to read OCGA.
I want you to run something, if you don't mind.
Go ahead.
Ask ChatGPT, why are so many indictments sealed and held in abeyance for monetary purposes? Let's see what it say.
Why are so many
indictments sealed, held in abeyance,
sealed and held in abeyance
for monetary purposes?
For monetary purposes. Well, it's saying there's no evidence that indictments are routinely sealed and held in abeyance for monetary purposes in the sense often claimed in conspiracy or prison bond theories. That said, sealed indictments or proceedings held in abeyance are real legal tools with legitimate uses. What is a sealed indictment? Now, I did check out sealed. You got something called under seal. Okay, and I see where judges have filed something under seal, but under seal has a double meaning to it. Under seal is for a bond. And so what they call under the clerk's under the statute merchant is called a commercial bond.
Well, that was really what I was trying to get Chat to come to.
The commercial bond.
That's correct.
And
it's being created right then. And
use the statute merchant, and it like when I held the my ChatGPT wants I'm trying to tell you, my ChatGPT it wants me. It had me do an entire.
I was trying to get it to come to that conclusion that they're structuring bonds from the beginning. They're not in a rush to exercise them or execute them.
But see, let me tell you something. See, I'm glad you did this, because that right here is evidence. Now, like how I would tell me this right here, that there's no evidence of that, I would start presenting ChatGPT with evidence. So, because it only pulls from what's available.
Correct.
So I would, what I would do in a situation
expand
like
its thinking, because there is evidence of that.
It is evidence of it. I've read docket sheets and see the commercial bond filed on there. And I'm like, well, if you go to the statute merchant, they say the commercial bond so held, and they got commercial bonds in there.
Let's explain to you what it does. First of all, you do know there's a judicial registry of funds, correct?
Right.
So the judge has its own set of funds. The prosecution team have their own set of funds.
Called the Court Registry Investment System.
That's correct.
Chris, right.
There you go. That's what funds them.
And that's where there's a document floating around. If they put in Court Registry Investment System, I don't know. I think somebody released that into the public accidentally, but they're minor cases, and it's showing where the minor cases have CUSIP. Now, every case has a CUSIP number attached to it.
You have to.
And so, I was doing real estate foreclosure, around 2010, around 2013.
Right.
And we were doing securitization audits, and we had a Bloomberg screen. And right on there, I came across a section where every case in America was on the Bloomberg screen.
Of course.
So I called up to New York, and I said, look, I'm seeing that y'all have all these cases y'all monitoring around the country. Can you explain what is that? And the man just told me on the phone, well, they just got it. He didn't want to give me any information about it. But I'm seeing it right there on the Bloomberg screen.
It's real. I mean, it's real. It's my partner, Ghazi, actually is a member of Bloomberg, and we see a lot of private to governmental stuff.
What's interesting? I used to go to this website called secinfo.com, and what it is it's Securities and Exchange Commission, but they list all of the. I went and did an investigation on Correction Corporations of America, which is a private prison system, and they're trading on the market. And I got their B424 prospectus and read it. And in there, they get a per diem for every day a prisoner is in a bed.
Now, you use the word, if you don't mind, the word prospectus. You mind telling your listeners what that is? Because in the industry that I'm in, everything is tied to a prospectus.
It's essentially a information about the security, surrounding the security, and explaining how money is going to get paid and what's going to be happening. It's a trust agreement, it looked like to me. It's an indenture agreement, because that's what Correction Corporations of America. You know what was interesting, what I found out? It's not anymore. They took it out of the trust status, but Correction Corporations of America was a real estate investment trust for the longest, a REIT. And I was reading them like, oh, they're a real estate investment trust. So just like McDonald's, people think that McDonald's is in the business of hamburgers, but it's not. It's in the business of real estate. The private prison system is in the business of real estate as well.
Correct.
It's just that the prisoners are how they create revenue.
That's correct. Well, not only do they just create revenue, but in order to monetize the entire structure is the number of beds,
Yes.
dollar amount tied to the number of beds, the number of mouths to feed. Okay.
Right.
That's what shows the value of the prison. So now I'm able to take the value of the prison and by a way of, I have maturity dates, 2025, 2028, 2030. You see, I have all these maturity dates. Now I get to take my entry data information to the bank, and now I'm able to borrow not just on the facility, but the housing. You see, it's monetization, it's debt, it's future, it's maturity dates. So this all falls into a banking system. It's just not, oh, they just love to lock people up. Well, no, they love to monetize this scenario.
You know, that's the first thing I learned, that that money or commerce underlies everything in the world. And I had to agree with that. How is money not involved? How is the court? Can somebody reasonably sit here and suggest that the court system is about truth, justice, and the American way, and not about making money like everybody else?
Not at all. Not at all.
You know, they say that a court is also known as a bank.
Well, I think it's proof of that. I'm not going to call any names on the Supreme Court, but you've had recent complaints of major corporations being able to take individuals on trips, and the same corporation had procedures in front of them, had cases in front of them. Would one surmise that the outcome would not be favorable?
It's not, and that is something to think about. But here's what something I discovered, and you tell me if you agree. I don't know. When I first got into this, right, a lot of people were saying they can do whatever they want to do. Right, that was, but I didn't believe that, and the reason I didn't believe that is
Well,
because,
let's talk about that.
okay.
Let's use right to travel. I don't have to show my ID. I can utilize a DOT tag, however everything is structured. But you hit someone in the middle of the road. You weren't paying attention. Are you saying that that person is not held accountable?
He's held accountable, but there are people. See, they think in this space that they can do anything they want to do as long as they don't injure anyone.
Okay, let's take the injury out.
Okay, well, that's not actually what the term is. It's really, you can do whatever you want to do as long as you don't violate somebody else's rights. And they have something called public rights doctrine. There is a case called Hill versus Hinkle,
okay,
where the judge explains in there that as a private American, you can do whatever you want to do. You're not under any duty to the government as long as you don't violate their rights.
Correct.
They missed that. They can go right now and read that and see it for themselves, you know. And this is what I tell people to do all the time, but they prefer to go with these narratives that are that issue from echo chambers from individuals who haven't even read the law or studied it, not principles of law, not definition of words or anything like that. And it spreads like wildfire, and it's very difficult to contain once it starts spreading.
Well, let's take the Amish, for example. They live in areas that are very limited in terms of utilities and different things of that nature. When do they cross over into the public? When they've caused what?
When they start selling stuff to the public.
Correct.
Yeah, they do sell things to the public.
Correct.
But for the most part, they try to remain detached. You know, they don't want cars. They don't want.
You can buy Amish furniture.
Yeah, furniture. They sell things.
And they were never ever taxed because they never created a tax. They grew their own food. They didn't have vehicles on the road, so there's no
tax.
There's no tax. But the minute that they generated revenue, they actually have a Amish corporation that actually sells all their stuff, and that corporation is taxed.
It is. It's absolutely
But what
correct.
happened? They decided as a nation or a group that they would utilize commerce to further subsidize their communities. But they left private and went commercial. So they are subject to taxation for that entity. Now, Amish are not stupid. They utilize the tax breaks and everything that goes with it as well. So one has to really analyze what they're saying they can do versus what reality is.
That's exactly right. It gets down to a public and private issue. You know, private ordering, that brings me back to private ordering. Private ordering really only has four tools that you can use, and that is contracts, private trusts, private member associations, and unincorporated private associations. That's it. And, once you understand that it's a structure that you have to put together, and it looks like they understand that because, yes, they pay a tax, but they don't pay a tax in their individual capacity.
Correct. They don't.
All right. They pay it in their corporate capacity.
That's correct.
And that is what capacity is everything. What I discovered is that there's a formula that the courts use, and it starts with a statutory definition. This is how a statutory definition is determined. All the words in the statutory framework are entryways into the statutory jurisdiction. It starts with terms. They define their jurisdiction. And once you cross that threshold, the first level of determination is whether or not you are a artificial person or a natural person. This is where we get into this misunderstanding of what a person is.
Right.
A person is a device that the public uses in order to classify individual conduct once it has engaged in a public regulated space in order to determine rights, liabilities, duties, and remedies. So, for instance, it goes to a statutory definition, and then it goes into the person, whether or not it's a natural person or an artificial person being a corporation or something like that, and a natural person being a human being. From there, they determine the capacity of that entity. Like, for instance, if you're a natural person, well, what capacity were you acting in? If you were acting in the capacity of a trustee, well, trust law applies to you. If you were acting in the capacity of an individual, which is the worst capacity, okay, there's a lot of liability attached to that. Now, you have a lot of control over determining what your capacity is. Like, one thing you could say, one of the proper ways I learned, you could say, I'm appearing specially, not generally, in my private capacity in order to determine the jurisdiction of the court, something like that. Mm-hmm. It's a capacity, and what I have found is what a lot of people do in the sovereign community is that they are creating capacities that are not recognized by the court. Mm-hmm. See, the public is already structured. Everything is defined.
Correct.
Everything has a procedure. Mm-hmm. And so when you come in and say, well, I'm a private state national, well, that's not a recognized capacity.
And you have to understand, well, individuals have to understand that there was a time period where when you walked in the courts, they didn't know what to say.
They didn't.
Well, that has changed.
They studied
education.
Everything.
There's continued education on dealing with private citizens or individuals that make certain claims that they're not privy or not to be included into the commercial capacities. Even to the point where now they've instituted laws on financial terrorism and things of that nature. And a lot of what people thought was success was individuals having no clue what they were talking about.
Yeah, I said this too. So I said sometimes judges don't want to deal with it.
No.
Look.
Not
Get
today.
out. I don't want to deal with this, anymore. And you're absolutely right. It's you don't know the reason cases get dismissed, really. But what you were just saying, that's the reason why I pivoted. Mm-hmm. I pivoted because they've studied this. They have a book out. It's a manual. And I got it on SPC University. They put out 2 of them. They have a meeting every so often and discuss all the sovereign doctrines and decide on how they're going to handle it. Mm-hmm. And, they got an intranet, attorney confirmed this to me. You have an internet and you have an intranet, which is an insular environment that only the judges have access to. Mm-hmm. And they discussed all this stuff. Sometimes when the judge gets up and leaves the bench and comes back, he goes in the back and he's talking on this thing. I got this guy in this courtroom, what I do with him.
Yeah.
And they tell him and he comes back and he handles you. Mm-hmm. So that right there is your evidence. Look, why are you going to try to use processes that people have been trying to use for 50 years? It's time to pivot. That's why I'm telling you, it's time to go to another way.
It's time to understand.
Yes.
It's time to understand.
Oh, very well stated.
And you don't have to pivot. You just got to understand. And the pivot comes with knowledge. Everything comes with knowledge.
Right.
You're going to have individuals that don't want to operate from knowledge. They're okay operating in the blind because they're set on what they want in terms of their own deemed type of freedom. So I guess with what you offer in your school and your ebook, how does that help people?
Well, the ebook, I'm glad you mentioned it, the SPC Doctrine. You can pick that up, by the way, at spcuniversity.com. There is an added bonus along with that where you can attend a webinar on private ordering to give you some perspective on exactly the things that we're talking about this in more detail. But that is, I'm offering clarification. That's what I'm trying to get right now. Before we can move into remedies, okay, we have to get to the foundation first. Foundation before remedies. What is the proper foundation? And then we could determine remedies. Remember the formula. In the public, they go through statutory terms. From there, they determine a natural person or artificial person. They get into capacity. Then it goes to classification. And from that classification, they're able to determine rights, liabilities, duties, and remedies. Nobody has taught y'all that formula, but that's the formula that every court on planet Earth utilizes. All right, so once you understand that formula, now we understand the framework. And from the understanding of that framework, now we can understand how to access our remedy. All right, but you can't access a remedy by making up your own out of thin air, not as it relates to the public. In the private, you can do that and with other individuals because you can make your own rules. That's what private ordering is. But there's already been a framework established. And if you're going to come into the public, you have to operate according to their rules. That's not to say that you're restrained from some sort of creativity. But if you want to exercise the creativity to access a remedy, you got to understand the framework you're interacting with first and get a clear understanding of that. And we have been provided a tool by the creator of the boundless universe that allows us quick access to confirm some of the theories and speculations that we've had. And that's why it's time to dispel with a lot of things that have been circulating for a long time that, quite frankly, have not benefited us at all. What is the success rate in this space? About 2%?
I'd have to challenge that. I'd have to challenge that. I've heard a lot of theoretical scenarios, and I've yet to see the person who cracks the code.
And that's the thing, like I have a Facebook group with almost 40,000 members in it. And I watch posts, and there are other Facebook groups, and they just all regurgitating the same information. It's just the same thing over and over and over again. I'm not that person. You don't have jurisdiction over me. I'm a private state national.
But that works for them, and I won't ever take that from an individual, because that's the beauty of the Constitution. You have a right to think and feel how you want to. I think what I like about you, or appreciate, which even caused me to share this information, is because those that are really looking to take care of their families, to provide a safe environment, to protect themselves, having to deal with the court system, let's take a father or even a mother, and they're locked up and they don't know their rights. Mm-hmm. That's devastating to a family.
It is.
One day, a car can be towed. Anything could happen that could change the trajectory of that family and where they're headed, to the collapse of the family. So information and knowledge is just so important for individuals that's looking for it. And I do believe that's the space that you're in. The people that are going to listen to you are going to listen to you so that they can become knowledgeable. The individuals that don't want to listen to you want to believe and think, and that's okay. They have that right to do it. But I think that individuals owe it to themselves and their families that as they enter into the information, and whether it's this information or how to run a business, how to open up a trucking company, everybody have to do things based on solid information that's going to take them from point A to point B. And so that's why I feel what you're doing is important.
Thank you.
Don't let anybody diminish what you're doing because they have things to call you. You're a sellout. You're working for the government. Get it, understand it, but that's what comes with truth telling.
Yeah, my students, they don't think that, in class, they see us going through the case law. They looking at the definition of the words. I'm studying and showing them exactly how I study. I'm teaching them, like, look, they're looking at the things I see, and I let them make their own determination about things. It's like, I'm not trying to give people misinformation. I've been doing this 20 years, man.
And everybody won't get it, though.
People, listen, let me tell y'all something. I've been doing this 20 years. There aren't too many people left in this space that's around that long. I'm the last.
What about the people that created information, sold it, and ran? Where are they?
Exactly. And I know some of them. We both know some of them. Yeah. They made a lot of money, too.
They made
a lot of money, too.
And they're living private right now.
And they're living privately. They got off the radar and ain't heard from them no more.
And they're not locked up.
They're not locked up. They are not locked up. And that's the thing, that's what I tell all my students. I say, my first duty to you is to make sure you don't get arrested.
Correct.
I tell them that all the time. That's my first thing, to make a safe pathway for you to achieve your goals and everything. And because there's too much information out there that I think that can get people into trouble, when they try to do it. But, I'm going to give you the foundation and take the time. I think it was the reason a lot of information is circulated. That's another thing I see is it's a lot of stuff to read. They want they want something fast. That's why so many things were popular, like birth certificate authentication. It's easy to do. Passport process. It's easy to do. It doesn't require you to do weeks of study or anything like that. It's a process somebody told you to do. Go authenticate your birth certificate so you could become the registered owner of your estate. A misinterpretation of Minnesota Rule of Practice 220. It was an individual who worked with me. I used to have a blog talk back in 2015. And I used to let individuals come onto my platform after I vetted them and made a determination that they were pretty knowledgeable about their subject matter. And he elected to do a webinar on birth certificate authentication. there was an individual by the name of Rodney Dale Class. He was one of the first individuals that I'd seen talking about Minnesota Rule of Practice 220.
Okay.
And I kind of just, I didn't really pay a lot of attention to it. I'm always seeing them talking about different things and things like that. But then he brought it to my attention, and he did this birth certificate authentication, and it blew up. And they did probably about 15 different webinars on this and made a lot of money. Well, I began to kind of question it a little bit, because after reading Minnesota Rule of Practice 220, I'm saying, look, this is not what this is talking about.
Correct.
That excited the ire of another group of individuals who said I didn't know how to read. And that's when I started doing the videos of me reading, just to let them know. I'm saying, you say I can't read. Reading is my thing, as all of you can see. And as a matter of fact, I did the videos to show the people, not only can I read, but I'm reading all of this information. And since you don't want to read it, I'm going to read it for you, and so you can listen to it. And that became, those some of my most popular videos.
Right.
Well, anyway, turn out that they don't understand the difference between a rule of practice, a rule of law, and a rule of court, because you don't really find it in the modern dictionaries. This is one of those times you do go to the older dictionaries, like Black's Law 4th edition or Bouvier's 1856. And in doing the deep, it only took me an hour to break this thing down, because after they did the video on me saying I didn't know how to read,
Right.
I got up like 6 o'clock in the morning, did the research, made a video, and put it out. It's called Finally the Truth About Minnesota Rule of Practice 220. And what it was saying is, look, it was talking about, it was relating to the Uniform Transfer to Minors Act, which basically is that when you have a minor, okay, a minor cannot title property into their name, because Minnesota Rule of Practice is under real estate records. It's 3 parts under there, and it's all under real estate. So we're talking about real estate. All right, so that's the first clue. We're talking about real estate, and we're talking about a minor. A minor cannot enter into a contract. All right, so since he can't, you have to title the property into a custodian's name. Okay, once that child reaches the age of majority, which is in some jurisdictions 18 and in others 21, okay, you have to bring them to court to prove, because they're going to transfer the title of this property into this person's name now. However, before that gets done, we got to identify this person. And you need 2 forms of proof.
Correct.
One is an authenticated birth certificate. Just because it came from vital statistics, authentication is verification. You can't introduce evidence into court without it being attested to under penalty of perjury. All right? That's number one. And number 2, you need an affidavit from a custodian attesting under penalty of perjury that this individual on the birth certificate is the same individual you're about to put on this real estate. And once they've confirmed that, then they can transfer that property into that minor's name. Now, a lot of people like to allude to an archaic interpretation of minor, which means an individual that is incompetent. And that is where they derive this meaning. But still, how are you using an obscure rule of practice? Rule of practice is just a procedure that attorneys use for introducing evidence in the court. It's not a law. All right? But they took a rule of practice, obscure in another state, and made it into a whole movement. And I put out that video 7 years ago, and people are still introducing that process. Some girl, she came out with a process on Treasury Direct, and you need to authenticate the birth certificate. As soon as I saw it, every time I see somebody having their process authenticate the birth certificate, I know it's a fraud. I said, it's fraud, it's a person. You don't understand what you're talking. And then some people were taking, like this one person, they made a lot of money. I'm mad about it too. They went off my site and out my Dropbox and took a lot of information and made a whole process out of it. Made probably about $500,000 selling it to people.
Oh my goodness!
On the Treasury Direct account. And then I made a video about it, and they all, if you go to right now, I got a Treasury, and read the comments, everybody like, you ain't nothing and everything. Did you ever get access to that Treasury Direct account?
And you asked me about what percent. I said lower than 2%.
Did you ever get access to it? All that, go over there and read all them comments. Did that age well? Just saying.
On that note,
man, this is we got to do this again.
we will.
We got to do this again. I wanted to introduce people to you. We didn't get to go into the DTC as much as I would have liked to, because I don't think people really understand how much of an expert you are in that field. You've been doing that. Man, when I met you, you were monetizing instruments. I'm talking about big things and things like that, traveling the world. And I tell people all the time, he was doing what y'all talking about doing. He's already doing it. Mm-hmm. And it's nothing like what you think, you know.
It's really about understanding the structure,
yes.
Understanding that there's a buyer, there's a seller, there's a settlement, there's a due date, there's a payment due, there's a project, there's interest. You have to accumulate all those things to do what we do. It's not easy. It's very complicated, very tedious, and very time consuming.
Yeah, I watch you every day. And, you present me with contracts to read, see if I understand it, and luckily, because I have this background in secured party, which is about securitization, I can understand a lot of the information that you give to me. I haven't put it into practice like obviously you have.
But here's the crazy part. It only takes one element to kill the deal.
Explain
one
that.
element. I can validate my value. I can validate my assets. I can validate my buyer. I can validate my seller. But if there is one compliance issue, the slightest compliance issue that the banks don't approve of, it's a dead deal.
That reminds me, when you're dealing with trust, when you just said that, listen, this conversation, I have learned so much and so many, I'm real, y'all. I'm saying we did this on the fly. We did not rehearse this or anything like this. And I'm sitting here, every time you say something, I'm like, well, equity, one of the principles of equity is in order to get equity, you must do equity. You have to have clean hands.
Correct.
And in reading the case law, when they say clean hands, they don't mean 99% clean hands.
Clean hands.
They mean 100% clean hands. And that falls right into the compliance issue. Look, you can't be 99% compliant. You have to be 100% compliant. Is that fair?
That's fair. You have private structuring. You have private bonds that anybody can create. You can structure. For yourselves, for your company.
Can you teach people that?
Oh, yeah, you definitely could teach that. Anybody have an opportunity to look up private placement memorandums that's tied to Reg D, 506B and C. And that's a structure that many developers use, okay? Basically, they go in and they create a project that they would like to finance or structure financing with private investors. It's a scenario that falls right outside the SEC. There's only one document that has to be provided to the SEC. But the essence of it is it's a private raising of capital.
Right.
And it's a process. It's a tedious process, but these are individuals that are typically in development, multifamily use, mixed use, commercial, real estate. And they go in and they raise capital through privatizing their structure. And it's made available to individuals that are willing to invest in a bond that has a maturity date. That ultimately they receive a coupon interest rate.
So they get the interest off of it.
Correct.
I mean, so yeah, that's where I want some clarification, okay? Because you talk about this coupon. That coupon evidences their entitlement right to receive payments.
Exactly.
Okay, so that payments is
when you get a car note, do you get a coupon?
I do. Yeah, I do.
Yeah. Well,
I do.
There's interest. There's a payment attached to it.
Well, I did back in the day. They don't give us those books anymore, but
technically they do.
Do they still?
You get them in the email.
Because I remember, in the email now, but I remember I used to actually have coupons for my payments.
Because when you structured that car note, that was a bond, and it has a coupon attached to it.
It's one interesting thing about car notes. When you read a car contract, on the back of it, they have something called a claims and defense notice. And this was I was studying securitization too. Another name for it is called the holder in due course rule, and it's put out by the Federal Trade Commission. And I went to the American Securitization Council. The chairman of that, I forgot his name, but he's the one who created securitization. Right? The American Securitization Council. So in reading his document, and I will provide it, I'm gonna put the link to this document under this video so y'all can download it. He was talking about how we are the original creditor and we don't know it. And so they had what's called the Financial Accounting Standards Board came to them, and it had this. It's called it was like some transparency type of thing that they wanted. And what it was this: they wanted. They got into an argument about when they securitize this. How do we determine ownership if you're going to sell these assets? It's called a true sale. Okay, and true sale is a bundle of rights.
Correct.
And how many rights do you have as opposed to the debtor? Okay, so in there they wanted to get 100%. They was trying to get 100% of the rights, but in order to do that, they had to give full disclosure. Yeah, that's what's called. It's called the disclosure document. The banks didn't want to give full disclosure. No. Okay, and because that holder in due course rule, what it is, it's a warning to the investors on Wall Street that if the debtor ever wakes up and finds out you retain one right, and that's called the right of set off.
But that's the part of the structuring of their note that allows them to sell it off like that.
Exactly.
So when you come to structuring private bonds and private notes, you have a lot of latitude, but the individual that's making the investment or the purchase has to accept it.
You know, I have to ask you this because I got the opportunity right now. I know we're going to be wrapping up in a little bit. Before we do, I wanted to talk about this a little bit. I used to read this book called Behold a Pale Horse by an author by the name of William Cooper. You know, he was real big in the conspiracy world. But in that book, there is a story called The Story of Jonathan May. Now, Jonathan May, he went to prison here in America. I think he did like a 12-year bid or something like that. But his story is really interesting. He inherited a lot of land. This I understand about what you're talking about because he's the first person to do this. He's the first. He created the land banks. He inherited a lot of land, and he formed about 100 different trusts. And he did a geological survey. He had gold, silver, all kind of elements in it, and he monetized that. And he only encumbered it. He did like 60% of it, like the valuation of it, whatever it was. He only did up to 60%, issued his own paper.
Correct.
And then he contacted the government to pay off the national debt, and they arrested him. And I challenge anyone can go get it. If you can read that story, and he marks out, it's an affidavit, everything that he did, and if you could follow along, you'll understand what he's talking about.
There's a lot to it. I just really highly encourage people to take their knowledge to the next level. There's so much to tap into with private bonds, private ordering, private structures.
Yes.
That allow you to take yourself to the next level. Don't get caught up in the portions of, I want to say, these extra freedoms. That's good for those who want to, but for those that are really trying to take care of their families, take themselves to the next level,
Start with something real.
Absolutely.
It was something real. And I think, I don't think people really understand the value of understanding I remember I was in jail, and one day I remember when it hit me, I said, there really isn't any money. People will hear that phrase, ain't any money, but do you really understand that? And that's what we're talking about. This is a debt-based system, and it's a game. And there are rules to the game.
It's a monetary system that's backed by debt, that paper basically does not transfer. It's held in a facility created based on all futuristic values.
Would you be safe to say if you learn that game, you could perhaps change your financial condition?
Oh, no doubt, no doubt, no doubt. If one takes the time to learn, and I learned from trial and error. I've learned from probably 98% failure.
Oh yeah, that's me too. I think a lot of us do that.
I wouldn't even deal with, and I don't really deal with many individuals that haven't failed, because the educational process that comes with that is the continual getting up, the continual starting over, the continual learning from the previous mistake. And to just satisfy oneself with information that's just put out there, that has to be unacceptable.
I remember one time you told me, that always stayed with me. You said, there's only a handful of people in the world that can monetize that.
That's correct.
And they all know each other.
That's correct. Very small world.
And I'm sitting across from one right now. Y'all better understand. I only put the best on this show. Hey, look, we're going to wrap this up. We're going to wrap this up now. Hey, man, I want to thank you. We're going to do this again.
I look forward to it.
Soon.
I look forward to it.
We're going to start. We're going to be coming to y'all with information like this, various topics on various things, and this is just a taste of what's to come. You know, I want to appreciate you coming out, man, and look forward to doing this again.
I look forward to doing it again too.
Hey, everybody, I want you to like, comment, and subscribe. I really want to hear your comments on this. This is our first major podcast. We're going to be doing this a lot. You can see I'm changing the structure of everything. Like, comment, and subscribe. Hit the notification button. Go to the website and get the SBC Doctrine Handbook. There is a bonus in there where I want you to come to these classes, and perhaps you'll get an opportunity to hear Mr. Brewer speak on the DTC and monetization of debt. But anyway, without further ado, peace. I'll see y'all tomorrow. You have a nice night. Peace.